All right, welcome to the joint hearing between the Senate and House Judiciary Committees related to fair and impartial policing, focusing on that. We're going to start with an overview of legislation that requires the model policy, and then we're going to hear from Executive Director Raquel from the Vermont Criminal Justice Council to go into the policy, and then we have additional witnesses as well. So Ben, if you could join us. Thank you for being here, Ben.
Thank you for having me. Closer than I normally said. Well, good morning, committees. For the record, Ben Novogratski from the Office of Legislative Counsel. I'll be doing a very general overview of the enabling statute that governs the fair and impartial policing policy. So to start, the statute is 20 VSA, section 2366. It's entitled Law Enforcement Agencies, Fair and Impartial Policing Data Policy, Race Data Collection. The statute was first passed in 2011. It's been updated several times since then. But really the main import is this establishes the statutory mandate for essentially every law enforcement agency in the state, county, municipal, and constables who exercise law enforcement authority and are trained accordingly, adopt a fair and impartial policing policy. And that policy must include each component of the model policy adopted by the Vermont Criminal Justice Council. There are specific mandates within the statute. So for instance, every 2 years, the council, along with the Attorney General's office and others, review the policy and update it if necessary. This last occurred in 2024 and was adopted, I believe, officially in April of last year. Once it's been adopted by agencies, the council and the Attorney General review the policies for compliance with those components that are established by the model policy. If during the review it's found that an agency's model policy is out of compliance, there's a mandate to work with the agency to get it into compliance. And even still, if those efforts are unsuccessful, the agency that's out of compliance is required to just adopt model policy as written by the council. There are annual reporting requirements by agencies confirming that, yes, they have in fact adopted the policy, and certifying to the council that officers have been trained in the policy as well. There's also an annual report to the legislature, the standing committee specifically on judiciary, regarding which departments and officers have in fact adopted the policy and whether the officers have received the training. Within the statute, there's a requirement to collect roadside stop data. That includes age, gender, and race of the driver, grounds for the stop, the grounds for the search, and the type of search conducted, if there was one, any evidence that was located, the date, time, and location of the stop, what the outcome was, and whether physical force was used or threatened during the stop, and if so, the type of force, and whether it resulted in bodily injury or death, and whether a written warning was issued, a citation for a civil violation, citation for arrest for a misdemeanor or felony, or there was no action taken. So essentially documenting the outcome of the stop. Law enforcement agencies are required to work with the Executive Director of Racial Equity, the Criminal Justice Council, and their chosen vendor with the goals of collecting uniform data, adopting uniform storage methods, and periods of time, and ensuring that the data can be analyzed effectively, The roadside stop data, as well as the reports and the analysis underlying that data, must be publicly posted. And my understanding is that it is available on the council's website or and specific agencies, I mean. Annually, law enforcement agencies must provide that data collected to the Director of Racial Equity and the vendor. And in the event the vendor is unable to continue receiving data to the council, agencies must provide the data collected in an electronic format so it's easily accessible to the receiving entity. This data must, like I said, be posted electronically, it must be analyzable, it must be accessible to the public, and it must be clear and understandable on each agency's website. So transparency is a big factor in this statutory mandate. Again, annually on December 1st of each year, those agencies must report to the Committee on Government Operations in the House and the Senate Committee on Government Operations, the standing judiciary committees, and the executive director of racial equity. It must show how the data is collected, how it's accessible, how it's used, review of the data to determine if more criteria is necessary to effectively capture roadside stop data, and any recommendations to improve data collection and how it's used. There's a definition of physical force in the statute. And then finally, subsection F talks about how nothing is intended to prohibit or impede a public agency from complying with the lawful requirements of 8 U.S.C. section 1573 and 1644. For those of you who are not aware, those are the information sharing statutes on immigration status between law enforcement agencies and the federal immigration authorities. There's a caveat that says to the extent that any
Question, Senator Vohowski.
I can let them finish his statement.
Okay.
this is the last
I just getting it first.
duly noted. To the extent that any state or local policy or practice conflicts with the requirements of the federal statutes, the enabling statute mandates that the policy or practice is that's in conflict, it's abolished. So there's essentially a backstop to ensure that anything that has to do with immigration that's in these policies must still be compliant with federal law.
Senator Vohowski.
So my question, and it may be for you in the statute, it may also be for the executive director, and it's if there's any other accountability mechanisms other than simply self-reporting.
As far as the race data collection?
As far as training, compliance, adoption of the policy, is it simply self-reporting or are there other accountability mechanisms? Are there audits? Does the Criminal Justice Council go in and look at what's happening and how things are happening?
Yeah, I would defer to the council on that, but outside of the statutory mandates, it is essentially self-reporting, and then the council reports up to, so it kind of goes up the chain, if you will.
Other questions for Ben? Not seeing any. Thank you very much. So we'll go over to Executive Director Brickell. Next, if you can unmute yourself, join us and identify yourself for the record. Thanks for being here.
Morning. Thank you for having me. For the record, Christopher Brickell, the Executive Director of the Vermont Criminal Justice Council. I would like to thank Lloyd Council for that overview of the statutory language, which eliminates some of the conversations I was going to have initially this morning. I would like to start out just by saying that the latest version of the Fair and Impartial Policing was a result of many meetings, many public meetings that involved a collaboration of many groups, not just law enforcement, but advocacy groups, including Migrant Justice, Human Rights Commission, the Attorney General's Office, NAACP, and many others. So this is a collective body of work that resulted in the latest draft of what this policy is. So for the committee's information, let me just start by going over the actual policy itself and the sections defined within the policy. So the FIP policy adopted in April of 2024 contains 9 separate sections. The first being a definition section. The second, which is policing impartially, which is basically discussing reasonable suspicion and probable cause, personal characteristics, citizenship, and immigration status. Section 3 is on community relations, and that's around building trust and transparency and providing name identification and answering questions by those that are interacting with law enforcement. Section 4 is around establishing identity, what types of or forms of identification are reasonable, and that when asking for identification, it must be based on a reasonable detention for a lawful purpose. Section 5 is around state and local enforcement authority and the priorities in federal immigration law. So the basic do's and don'ts of federal civil and criminal law. Section 6 is the interactions with federal immigration officers. That's basically speaking to the federal statutes and the restrictions on access to individuals. And then Section 7 is responding to bias-based reports or reports regarding bias from the community. And essentially what that does is it explains the process to the public when they make complaints, and that guides law enforcement that they do not respond to complaints that are solely based upon physical characteristics. And then Section 8 is training and what those mandates require. And Section 9 is around accountability and compliance, which somewhat speaks for itself, but it's the process of receiving and handling complaints. So what has changed with this latest policy? There are 3 main changes that occurred within the policy in 2024. And again, these were based on substantive and many committee meetings that were held publicly. And Section 2 on policing impartially was around citizenship and immigration status as a factor in Rule 3 determinations. So the latest policy language says that citizenship or immigration status shall not be used as a reason to arrest someone instead of citing them, and shall not impact the decision on whether to seek continued custody pursuant to Vermont Rule of Criminal Procedure 3, except that criminal liability for offenses where one's citizenship or immigration status is an essential element is a factor that may be considered in Rule 3 determinations. Now, that's not any different, not in contradiction with Rule 3 as it currently stands. And back in 2017, the policy noted that a person's undocumented status should not be used as a presumption for a flight risk. So this newer language is much more defined and says that only if the essential element of the offense is related to citizenship or immigration status, that would be the only time that Rule 3 would come into being a factor. The second substantive change.
Before you go forward, sorry, a question, Representative Dolan.
Yes, not a question. I think I was going to offer this for help. The policy is online, but I don't think it's on our committee page. And so I was just going to share the link with Nate to see if we could get it up there so we can stop. Oh, perfect. Great.
Step ahead of you, but thank you very much. So proceed. Thanks.
Thank you. The second substantive change was to Section 5 under federal immigration law. Excuse me. And that's essentially dealing when and under what circumstances law enforcement agencies may investigate suspected violations of federal criminal immigration laws. And that language now states that though agency members have authority to enforce federal criminal law, enforcement of federal criminal immigration law is generally not a priority for agencies. Accordingly, members should not make warrantless arrests, detain individuals, facilitate the detention of individuals, or otherwise expend resources investigating or enforcing unlawful entry or unlawful re-entry cases unless such actions are 1, necessary to ensure public safety or officer safety, meaning an imminent risk of physical injury to the subject, the officer, or a third party, or 2, It's integral to the investigation of criminal offenses unrelated to immigration law. And that policy further goes on to describe
So,
that,
I apologize again.
no worries.
A question from Senator Bachowski.
Yeah, I have a clarifying question around immigration law. I thought immigration offenses were civil offenses, not criminal offenses.
There are civil immigration offenses as well as criminal offenses. Vermont law enforcement officers do not enforce civil immigration law at all.
Okay. Can you help me understand the difference? Because I was under the impression that being, undocumented, for example, was always a civil offense.
Being undocumented is a civil offense. So the only time when law enforcement would get involved in anything immigration related would be during the potential criminal investigation of any criminal activity that a law enforcement officer might come across, where when identifying somebody, they might be asking for the documentation that somebody has to prove their identity. That does not necessarily mean that the law enforcement officers are going to take action on a federal criminal statute violation. They're focused on Vermont state law, not federal law. They are, however, allowed to enforce criminal violations. And there are some examples that perhaps a little bit later in your testimony that you received today might be more helpful that you hear from the Attorney General's office, that the complexities or the nuances of when those things might occur.
Okay.
Moving on a little bit later in that section, it also includes that the following do not on their own establish reasonable suspicion of a criminal offense and are not sufficient to warrant an investigation. And those things are personal characteristics, including somebody's limited English proficiency, citizenship or immigration status, and the presence in the United States without authorization or formal documentation and proximity to the border. So those things in and of themselves do not rise to the level of reasonable suspicion for a criminal offense and do not sufficient warrant a reason for investigation. Section 3, not Section 3, but the last substantive change to the policy was relative to Section 6, and that's on interactions with federal immigration officers. And that essentially is detailing when and under what circumstances law enforcement agencies may grant access to individuals who are in custody to federal agents, both inside and outside of the agency. That language has been updated again now to read that under restricted access, unless federal immigration agents have a judicially issued criminal warrant or a legitimate law enforcement purpose exclusive of the enforcement of civil immigration laws, agency members shall not grant immigration authorities access to individuals located in otherwise restricted portions of the agency's facility, absent a court-approved search or arrest warrant relating to alleged crimes, or permit immigration authorities to use agency facilities for investigative interviews. So essentially, unless there is a signed, judicially approved warrant or a search warrant, federal authorities would not have access to the restricted areas inside a local agency. It also goes on to further update the language for restrictions outside of the agency. And that states that unless federal immigration agents have a judicially issued criminal warrant or a legitimate law enforcement purpose exclusive of the enforcement of civil immigration laws, that the agency members who have an individual in their custody shall not grant access or otherwise facilitate immigration authorities access to the individual. Those are the three substantive changes to the language in the fair and impartial policing policy, but there were also two additional sections that were added. And these were really in response to some of the advocate concerns. And they were updated under Section 4 in the section of establishing identity. And they are caveats B and C. And B says that absent reasonable suspicion of unlawful activity, agency members shall not require that passengers in motor vehicles provide identification or other documents. And if requesting such documents, agency members will state that passengers are not required to provide them. A passenger not providing identification does not constitute reasonable suspicion of unlawful activity. And in no instance shall the enforcement of civil immigration law be a reason to request identification or other documents. And it refers them back to Section 5, which outlines that purpose. Also, the addition of subsection C, which says that in instances when a standardized form has a field requesting an individual's social security number, agency members may request such information for the purposes of establishing identity. However, an individual not providing a social security number does not on its own constitute reasonable suspicion of unlawful activity. The absence of a social security number is not indicative of citizen or immigration status, and in no instance shall the enforcement of civil immigration law be a reason to request a social security number. And that's common even in folks that when we're not talking civil immigration issues, just in folks in Vermont that come into custody of law enforcement. Many don't have identification that includes social security numbers, nor do they know them. So that's not really that much of a concern, but that was added to the policy to address some of the concerns that were brought up by advocates. Moving to the training section on the fair and impartial policing policy, the VCJC.
Just one, before you proceed, I apologize, Representative Harder.
Thanks very much. And thank you, Director, for your testimony this morning. I just, before we go into fair and impartial policing, I just have a question about immigration specifically. And I think one of the things that has been alluded to thus far is the distinction between illegal presence and illegal entry. And while illegal presence is a civil violation, illegal entry is a criminal violation. And I'm curious if there's any instances in which law enforcement in the state would be deputized by Homeland Security to enforce the Immigration and Nationality Act.
I may not be the best person to answer that for you. To the best of my knowledge, no, there are not any law enforcement officers that have been deputized by Homeland Security for those purposes. And you are correct, crossing entry into the United States, crossing the border unlawfully is a criminal violation, but as the policy states out, that federal immigration is not a process or a subject that Vermont law enforcement officers are concerned with. And it also states that unlawful entry, including re-entry, is not something that Vermont law enforcement officers should expend any resources on.
But to be clear, illegal presence via illegal entry is a criminal offense. It's not stated.
Again, I would refer you to the attorneys potentially in the room, but illegal entry is a potential criminal offense. Illegal presence without documentation is not.
But I'm saying if you came into the country illegally and you are here without legal documentation, that is a criminal offense.
That is a federal criminal offense.
Correct. Thank you.
You're welcome. Moving on to the training, again, fair and impartial
I
policing.
apologize.
No worries.
Chris, Senator Bahowski.
May also actually be a question for the attorneys, and I did see our legislative counsel was ready to jump in, but I wonder if you can speak to the interplay between asylum seeking and how that seeking safety moves around being able to enter into the United States to ask for asylum.
Vaguely, yes, that would be a much more appropriate answer for legal communities to answer for you, but you are correct that other ways of reentry or entry into the United States without documentation, such as asylum seeking, is a valid way of coming into this country. So there are reasons to investigate further the rationale for why somebody is entering into the United States, and that may not involve a criminal offense. So there are avenues by which that can be done. But again, that would best be answered by your legal folks in the room.
Thank you.
And we have Julio Thompson from the Attorney General's office, who I'm sure can also get into this a little deeper if need be, as well as Ben Nadrowski. So are we good with this? Shall we proceed?
You have your hand up.
Yeah. Did you want to wait?
I was just gonna quickly give a small example
Yeah.
of civil and criminal immigration.
Go ahead, please. Ben, please.
So for instance, criminal immigration offenses include improper entry and re-entry. marriage and entrepreneurship fraud, so essentially where someone knowingly enters into a marriage to evade immigration laws. Smuggling and harboring aliens, document fraud, so essentially committing fraud on your applications. High-speed flight from immigration checkpoints. So that's an example of some criminal ones. Then civil ones are improper entry. But improper entry, that's in addition to the criminal penalties, there can also be civil penalties imposed, so they're both. Unauthorized employment is civil. Document fraud can also be a civil penalty in addition to criminal penalties. So those are just some examples of the dividing line between criminal and civil immigration offenses.
Thanks, Ben.
I have a follow-up.
Yeah, Representative Hart.
And this is to you, Ben. Is that consistent with other states, both in New England and in the United States, or can we, like, would we expand criminal offenses?
These are federal offenses.
They're all federal.
Yeah, there are no immigration related offenses.
But are there any policies specific to the state of Vermont that we would potentially modify?
Policies as far as the fair and impartial policing policy outlines a lot of what Vermont's role is in immigration enforcement. So that's a policy.
All right, please continue, Executive Director Raquel.
Thank you, sir. Moving on to the training conducted by VCJC. Just for the committee's information, both fair and impartial policing and anti-bias training are provided to every basic recruit class who receives certification. This training has been supported for several years by the Department of Public Safety. And then following the certification of an officer, every odd year, officers, and that's all Vermont certified officers, are required to take fair and impartial policing training. This training that we have now is competency-based, and this year's training has 4 separate modules that outline understanding the policy, comprehensive review of the newly adopted policy, demographic and data collection, and then there's a section on motor vehicle stops, video car stops and scenarios, each followed by a competency assessment. This training is utilized and was participated in by 4 council members and our community inclusion director, as well as staff. That has been available since, I believe, the end of March, if not the beginning of April. So far, we have almost 800 officers that have completed the training. They do have until the end of the year to complete that training. And then specific to accountability and compliance, that section speaks to basically the process for complaints that should be readily available to the public. All agency members are required to report allegations of biased policing to their supervisors and to their department's internal affairs investigation function. State law also requires that all agencies conduct valid internal affairs investigations on reports of willful violations or substantial deviations from this policy. The council, as well through Act 56, can impose sanctions on an officer's certification up to and including permanent decertification. And lastly, a couple of comments that I'd like the committee to be aware of is that, you know, the Vermont Criminal Justice Council takes fair and impartial policing very seriously. The legislature and the governor supported 2 positions here at the council, a community inclusion director and a full-time fair and impartial policing instructor. We are all aware of the fears that community members are experiencing, and we have made our FIP policy available on our website. And recognizing those concerns and public fears, our inclusion director, in concert with the Fair and Impartial Policing Subcommittee, drafted a statement to communities explaining basically what our FIP policy is and what it is not in plain language. And that was really for the clarity of those that are impacted by this work. This statement was reviewed, it was approved and supported unanimously by our 24-person council. And with the help of the Office of Racial Equity, that statement, as well as our FIP policy, has been adapted to 13 different languages, most represented throughout Vermont, as well as a video for American Sign Language folks that can access the policy as well. And one last final piece, I just want to make sure that, again, I reiterate that this policy is the outcome of numerous public meetings, input from Migrant Justice, Human Rights Commission, NAACP, and others. And while not all the protections desired by advocacy groups were approved, many of the accommodations were made, including adding some language. And where we do not align with requests are based on following the law. So law enforcement officers must not violate federal law. And this policy really balances the desired protections with following the law. I like to refer to those balances as guardrails. Others refer to them as loopholes. And while I understand that fear that's out there, I think sometimes describing these guardrails as loopholes makes it difficult for affected communities to really be able to build trusting relationships with Vermont's law enforcement. You'll hear from law enforcement partners today just how much they're impacted or they get involved in civil or criminal immigration issues. I think you're going to find it's very minimal, but they would be the best ones to answer those impacts for you. So that's my testimony. I thank you for your time. If there's any other questions, I'd be happy to answer them.
I'm sure we probably have some questions before we do very quickly. On our website, we have training materials. If people want to dig even deeper into this, they can see the kind of training that is provided by the Criminal Justice Council. So that's under Kim McManus's name on our website. Questions, Representative Dolan?
Thank you. Thanks for the overview of the model policy and the changes to it. And maybe I missed this, but where does the data collection come in? Is that separate from the policy, or is there a procedure for that as well?
I'm sorry, I didn't hear the complete question. Was this around corrections?
No, around the data collection with the roadside data. Is that a separate
Yes.
policy, or how is that?
Data collection is intertwined with fair and impartial policing. Every time that a motor vehicle stop is made by a law enforcement officer, data collection is required. That required data collection has to be sent to us at the council. As you heard earlier, that data collection has to be analyzed and be available to the public. I will say that over several years, what we have learned from entities that have reviewed that information, including the Office of Racial Equity, that Vermont's sampling analysis is really so small that it doesn't, while we can collect quantitative data, we're very difficult at providing qualitative data. That's been done by outside entities, including National Police Institute, the Crime Research Group, and we struggle with that based upon the size and the amount of data that we do collect.
Senator Wachowski.
Thank you, Director Burkell. Is every law enforcement organization now in compliance with the policy and trained?
In theory, yes, all but 3 we're still currently working with. But during those working with those 3 agencies, per statute, the council's policy is adopted and they must follow and enforce the council policy. We have 3 outlying agencies that we are currently working with. We've had meetings in the last 3 or 4 weeks with one community where we're trying to negotiate what the council's policy is that they have already adopted with a welcoming ordinance that they adopted prior to the council's policy, trying to iron out what those differences are and seeing if there's some modifications that can be made that are happy to both parties. But there are still 3 entities out there that we are working with.
Okay, great. And then my next question is about the data. And so I know that I've heard in previous years that the data being collected at motor vehicle stops was somewhat inconsistent. Has that been improved so that data is being collected more consistently?
I believe it's always been collected consistently. I think the trouble is that some of the information that was being asked for while it was being collected, it wasn't mandated in statute, which it now is, which was around the date, time, and location of motor vehicle stops. That was additional language that was added so that we could have that within the statutory framework. But again, I think that there's been some confusion with, and I think the best way to describe it is law enforcement's efforts to provide as much information as they can sometimes conflicts with the requirement of the data to report. So, for instance, it's supposed to be on motor vehicle stops and their interactions that officers generate. While initially a lot of information that we were collecting was traffic tickets that may have been issued by law enforcement agencies that were not the result of a traffic stop. So for instance, a crash investigation where sometime later somebody was issued a VCVC for a violation, those were being reported as well. And then were somehow, they were implicating some of the problems that we were seeing in data collection, that it wasn't per the statute and per the requirement. So there have been bumps along the way. Law enforcement is continually working to try to improve those, but they all are reporting their data, and we are making sure that we get the data collection from every agency.
And I'm not the best at remembering dates, but I believe the fair and impartial policing policy was something that the legislature passed in 2017. When was the first fair and impartial policing adopted statewide?
To my knowledge, there was a policy back in 2016 that we were following before the mandate in 2017. That policy was a statewide policy as soon as that was adopted by the legislature.
Okay, and so the data has suggested that there is a racial bias in motor vehicle stops. Has that improved since 2016?
Would not be the correct person to answer that for you because I am not a data analyst and I don't know that those findings would be the most appropriate way to characterize the differences that we see in traffic data collection.
Yes, Senator Norris.
Thank you. Thanks, Director Burrell, for being here. Sounds to me like the council's doing a very good job down there, and you're very proactive when it comes to fair and impartial policing throughout the state of Vermont. I was wondering, have you had the opportunity to look at S-148 prior to this testimony?
I have briefly, yes.
And now, any discrepancies is there anything in the fair and impartial policing policy that does not presently cover what's being offered up in S-148, in your opinion?
In my opinion, some of the new language in S-148 would be problematic. It would put Vermont law enforcement in direct conflict with federal law.
Okay, and one follow-up question. If memory serves me correct, when it comes time for either VCVs or even warnings, and you require the officers to check all the boxes on these tickets, and one of them happens to be the question of race. And because an individual chooses or may choose not to answer that question, I believe at one time the requirement was to simply check the box, and it was done at the officer's best guess.
That is correct, Senator. It's based upon the officer's observation, not an answer by the person operating the vehicle.
So the data could have some flaws in it, should we say?
Absolutely.
Thank you.
Other questions? I just said, go ahead, Representative Rachel.
So I'm curious about the 3 towns that you're working with, and have they ever, can you give us a little more background on what the situation is in terms of one? It sounds like you're meeting with, but is there resistance? Have they ever had these policies? Are they submitting the data?
Yes. So I will say, let me be more accurate in that. 1 is an agency and 2 are towns. And so, yes, all agencies are reporting their race data collection, and all agencies have fair and impartial policing policies that have been approved. Once the year passes, the council reaches out to every municipality to make sure that their policies are in compliance with the essential components of the council's policy. And when there are differences, those issues come up, and that's when we reach out to those agencies to find out what those differences are, and we try to work out any conflicts that might arise between our policy and what their policy is. These are not what I would term in any way defiant. One that we're working with is the town of Hartford that we mentioned earlier, that has had a welcoming ordinance years before the council's policy that was adopted by their town, that included additional protections that I think, again, maybe the Attorney General's office could speak to later in testimony, but those additional protections are somewhat in conflict with the council's policy. So we're trying to work with them, and we have met with them regarding their policy and making sure that where we can align with their welcoming ordinance, that we can, and where we can't, we don't want their law enforcement officers that are following the council's policy to be out of compliance. The second is the town, if memory serves me right, of Richmond. There again, the town of Richmond offered some additional protections that didn't align with the council's policy. So we have worked through a couple of iterations of that. We have another draft policy from them that I don't believe the Attorney General's office has yet had the time to review. And the third party is the Essex County Sheriff's Department. And they have submitted two separate policies that are different from the council's policy, where there were conflicts within the policy created by their agency. And again, we're working with the Essex County Sheriff's Department to have the latest review of the last draft that they just presented to us back, I want to say 2 to 3 weeks ago.
So one follow-up question. The two towns that are offering additional protections, our statewide fair and impartial policing policy is a ceiling and a floor. So a department can't offer more protections.
The department can offer additional protections if they choose to do so. Those additional protections, however, cannot move to the area where they would violate federal law. So that's the legal responsibility, I would say, of what the Attorney General's office does in their review, is making sure that whatever additional protections that communities want to add don't put it in conflict with the council's policy.
Thank you.
So just the last paragraph of the policy deals with violations of the policy. And could you just expand a little bit more about how those were addressed? And also, if you can tell us how many disciplinary proceedings there have been with respect to violations or violations that have been reported? But if you could first just kind of describe the process and then tell us how much it's being used for any kind of violation.
Sure. So the process again is that each agency has to have an available process for folks to make complaints. Agencies are required to self-report anytime that they see a violation where there's a willful violation of the fair and impartial policing policy or a substantial deviation from that policy. The council does get those complaints through the Act 56 process that are reviewed. And then they're also reviewed by a subcommittee of the council, the Professional Regulations Subcommittee, to see if in fact there are violations of those policies. And then ultimately they go to the council for review if there is in fact a finding of a violation of those policies. Each agency is required by statute to have a valid investigations process. And if that investigation process does not appear valid and when it's submitted to the council, we have the ability to launch our own investigation or other form of investigation if that doesn't meet the standard. So that process hasn't taken place, but we have several times gone back to agencies asking for more and further information during investigations. And again, regarding Act 56 violations, they are confidential by statute, but generically speaking, relative to the topic of immigration and communities affected by the fair and impartial policing policy. I can say that there have been, in the last 2 years, two complaints that have risen to the level for the council. And of those two complaints, one was self-reported by the agency after the fact, not realizing that there was a violation. And then upon further examination, they realized that it might be a potential policy violation and they reported it to us. The other one is still currently being investigated.
Thank you. Any other questions? Yes, Senator Mahowski.
Thank you. Can an individual community member make a report to the council, or are you relying solely on the self-report of law enforcement organizations?
No, we take complaints from any source here. We take them anonymously or the phone, by email, in writing. Complaints can be accepted from any source, as well as by the agencies from any source.
Okay, that is helpful to know that a community member can come directly to the council. And that would be investigated in the same way as a report from an LEO.
That's correct.
Are there any active accountability measures, random audits, community surveys, or are you relying solely on a reactive, complaint-driven accountability?
Well, accountability starts first and foremost by complaints that we do receive, but we also have auditing capabilities that we do here in the way of agencies attesting to compliance and having the policies on hand. We've actually just started with the advent of being able to hire an investigator here at the council with audits that are going to be starting out, in fact, this coming month from our agency, reaching out to agencies indiscriminately, where we're actually going and identifying that they physically have these policies, they have investigative procedures in play. So it's not simply responding to and taking the attestations from agencies that they are required to submit to us every year.
Okay, that's helpful. My concern, and there may not be a good answer to this, but a lot of the people we're trying to protect with this policy may naturally have somewhat distrust around these organizations and may be fearful to even make a report. What is being done to connect with those groups of people to dispel that fear?
Again, you're right. That's a difficult one to answer. I mean, we have made some efforts with our community inclusion director, reaching out to different organizations. We've invited several folks here to the academy itself so that they get a firsthand look at what it is that we do here and an understanding of the policies and what recruits go through. You know, we're reaching out to, I've reached out to agencies in June. We're going to be hosting a naturalization ceremony here at the academy. I think it's important for any outreach that we can do to make sure that communities that interact with law enforcement know that we're not the enemy, that we're here to protect them as well, and that law enforcement does the best, available job that they can to make sure that they're following policy and that they don't impact people regardless of their immigration status here negatively. That's not the intention of law enforcement, and that's hopefully what this policy helps address.
Thank you.
Representative Harding.
Thank you, Chair. Director, what I'm hearing from your testimony is of the two violations, one of those was self-reported. And the way that I interpret that is that in light of what you just said about the naturalization ceremony, it seems like the council's taken a lot of very proactive measures. And I'm curious if there's any other proactive initiatives that you want to highlight and explain to the committee here today.
Well, I think the fair and impartial policing training that we've offered this year is legitimately different than training that we've done in the past. And even though this training is online, it's much more comprehensive, it's competency-based. We're making sure that officers are getting the information that's out there. And we're really reaching out on an effort from our part just to make sure that folks know that, we're making the best effort possible to make sure that we're treating Vermont's law enforcement as appropriate, because, law enforcement interactions happen every single day. And sometimes bad things can happen, and we don't want those things to be happening unintentionally. And I think it's difficult during these times when we see federal authorities acting in ways that may be lawful, but may not be the way that Vermont law enforcement authorities would react with communities. And we spend a lot of time, here on communication, de-escalation, treating people, with respect and empathy. And that's hard to combat. I think law enforcement does a great job of doing that every day and trying to build those relationships with people. So anything that we can do, we're going to work towards making that fear try to dissipate as best as we can.
Thank you very much. And thank you for all that you do on a daily basis to make sure that our communities and our state is safe.
Thank you.
So just one last thing, if you could, the statement that you mentioned earlier that was sent out, if you could send a copy to our committee assistant so we can post that, I'd appreciate that.
I'll absolutely do that.
All right, thank you very much for your testimony, and we'll turn to Chief Pontbriand next. I think Jennifer Morrison will be showing up, but she had another appointment and will be here a little bit later. So over to you, Chief. Thank you for being here.
Good morning. Nice to see you as well. For the record, my name is James Pontbriand. I am currently the Chief of Police for the Berlin Police Department. I also represent the Vermont Chiefs of Police Association as a Vice President. And I am currently sitting on the Vermont Criminal Justice Training Council. In addition, I help facilitate a regional program for internal affairs investigations, which any law enforcement agency other than the state, if they have their own resources, is welcome to approach me and help them with internal investigations.
Yeah, great. So if you could kind of explain how the model policy is used in just generally throughout the state, like to kind of get an idea of actual. We've heard the policy, and we'd like to kind of understand how it actually works in practice. And the squeaky toy of your dog does not bother us either. I think
I was about to give you a word of caution that you may hear some noise in the background here. Just give me one quick second.
I thought it was Representative Dolan.
Oh, the poor dog is getting his toy taken away. All right.
I apologize that she actually was a rescue from a very bad car crash where the driver took off on foot and left her behind to face the consequences. But she's in a safe place now. Back to the matter at hand. So, like was mentioned before, Director Burkell mentioned before, it acts as a guideline or a framework for us. This is not. Immigration law has really not been a focus of any municipal law enforcement investigations for a number of years. And more recently, even more so, because we understand Vermont's stance on this. And it's just not a priority for us on any level.
So how does the model policy then affect, day-to-day interactions that law enforcement has with individuals?
I think it serves as a reference and a constant reminder that we have to work within these guidelines. I know that it on occasion will generate good conversation. There was an incident that happened a few weeks ago where because immigration enforcement has picked up, local law enforcement is seeing more activity as far as warrants that are being issued on the federal side of the house. And something new to us were detention orders. And it generated discussion among law enforcement leaders at my level about what is the difference between a detention order and an actual warrant. What would this look like if officers encountered it, and what actions would we take? And this kind of demonstrates how the policy is working, is because this was a very real situation that we are currently facing. And how does the policy come into play, and what action should we be taking? And it generated a lot of good conversation among leaders, and referred back to the policy. And then furthermore, it was an opportunity for me to come to my officers and reiterate the policy. This is what you may encounter. And this is what the actions are that we should be taking.
So what, I have a couple other questions from other members as well, but what was the upshot of that discussion on how to address detention orders as opposed to judicial warrants?
Sure. Detention orders are civil issues, and we would not take any action on those.
Okay, appreciate it. Representative Dolan and then Senator Mahowski.
Yes, thank you for coming today. I guess I just wanted to hear more about that. If you could talk about that shift that you've been seeing. Sounds like within the past year with immigration, there have been requests, the number of incidents, and I appreciate that they're probably happening in pockets around the state. So how are folks communicating that to all departments and just sharing that information? I know there's the training, but it seems like this is in application right now, like you're having more instances of it. Can you just talk about that?
Certainly. I can speak, not for myself. We had not particularly here in Berlin encountered any of those. But there are several like lines of communication. One, through the Chiefs of Police Association, we communicate questions that our departments are facing almost on a daily basis, and just getting feedback from other department heads of how they're addressing those issues. Do they have policies in place? Can we borrow those policies? And there's a lot of discussion pretty much on a day-to-day or a weekly basis with a variety of issues. And this is just like one of those. We also have, for most municipalities, the League of Cities and Towns, which provides some legal and framework when it comes to policy that we can always refer to.
Senator Mahowski.
You actually each asked my question, so I don't need to ask it again.
Okay. Other questions for the chief? All right, thank you very much, Chief. And we'll go to Mark Anderson next, and then after that, we'll hear from Jennifer Morrison. Mr. Morrison.
Thank you, sir.
Thank you for being here, Sheriff Anderson. Appreciate it.
Thank you for your time. For the record, my name is Mark Anderson. I'm the Sheriff of Windham County and President of the Vermont Sheriff's Association. You've already heard quite a bit of testimony. I'm happy to respond to questions, but I can just briefly say the Sheriff's Association is a member organization that represents 12 of the 14 sheriffs. We put forward training to help professionalize sheriffs and build stronger communities that we have. As I was listening to the testimony that preceded me, there's some irony in it because I was also sitting here saying, much like the medical field, I can look at some of these questions and say, well, I recognize the bone's broken or something's bleeding and it needs treatment, but I'm not a doctor. So there might be some things I know, but at the same time, I couldn't really speak about them like a doctor could. And so when we talk about what federal immigration laws are and the criminality of them versus the civil nature of them, I know they exist and I can't even speak to them beyond more than just broad layperson knowledge because we don't train on it. This has been enlightening, but also at the same time reinforcing the concept that Vermont law enforcement has not historically focused on immigration enforcement or immigration laws. And some of this is even contextual to the point that I started Vermont law enforcement in 2004 and not being able to answer some of the questions that the executive director presented. He was a chief of police before his work at the academy and preceded my time in Vermont law enforcement. So it's interesting to hear what different generations of law enforcement have for knowledge versus what someone of my generation has. Again, I'm happy to answer any questions, Mr. Chair. I'm not sure if you'd like to hear testimony on a specific area, but I think you've heard a lot already.
All right, Senator Mahowski.
Thank you, Sheriff Anderson. I'm wondering if you can highlight what the challenges have been in Essex County to the Sheriff's Department there coming into compliance and what the Sheriff's Association is doing to help them get into compliance.
So one Sheriff's Department that you've heard testimony on that's not in compliance is not a member of our association. They stepped away from us back about, I want to say 6 or 8 years ago. So we are not directly involved in that. In the context of the association, we normally provide support to our member organizations. That department separated on its own. So we have no control of that. Obviously, we can't compel membership to our organization if someone doesn't want to participate.
Thank you for that. That is helpful information in and of itself.
Representative Dolan.
Yes, wondering if you could speak to the question I asked the previous witness of just, are you seeing, for sheriffs, new opportunities where you're putting this policy into play, application of it? If you could speak to any of that, are things shifting at all?
So it's interesting. I've been involved in the work around this policy since I believe the original iteration came from 2013. It was, or I should say, the statute started in 2013, maybe even as early as 2011. And I think, from my perspective, over the last roughly almost 20 years that my department's been involved in this type of work before the legislature passed the requirement all the way up to now. We've come to a place that the law enforcement organizations, along with various different stakeholders, now have shared language and shared understanding. We might not always agree, but oftentimes those disagreements usually come down to issues around federal law that we have no authority. It's interpretations by either the U.S. District Court or the Appeals Court around interpretations of certain laws that exist. So to that end, are we seeing new things? My experience is that we're not really seeing too many new things anymore. Most of the quote unquote things with the broad brush are generally understood, known, they're trained on, but there are times where questions are presented that are generally of a legal nature, which then we turn to attorneys, Attorney General's office, the Criminal Justice Council to say, how do we navigate this question? So we are not seeing any significant changes with the way that we're engaging with the public or being asked to engage in new ways that are out of the norm. Our fair and impartial policing policy has generally been pretty consistent in how Vermont sheriffs apply our practice.
Other questions? So just a general question as well. Any difficulties or frustrations in implementing the fair and impartial policy that you wish to share?
The frustration, this is going to just be Mark Anderson talking. I'm not representing anyone other than myself because I was not prepared to answer that question. So just for me, a frustration I have is this is one of the most complicated policies we have. It's not to say that that's a bad thing, but it is. And so there are so many difficulties in trying to explain to my staff, this is what I want you to do when you have a decision to make and you have to make it in a split second. And I want you to know that when you do the right thing, I will support you. And when you do the wrong thing, I will hold you accountable. If I can't clearly explain what I want them to do or not to do, when I can't be there to answer their every question 24 hours a day, 7 days a week, that's a hard thing as an agency head to say, how do I support you doing the right things and hold you accountable for doing the wrong things? We want to establish trust not only within our employment, but also within our communities. It is hard when we are trying to communicate with disenfranchised communities while it's being reinforced that we are actively engaging in behaviors that we have no involvement in. So those are frustrations we deal with. That's not anyone's fault. This is process. This is democracy. This is the way that things do play out in the world that we've lived or I've lived in professionally for the last 20 plus years. So are there frustrations? Of course. Who doesn't have a frustration with the day-to-day of any activity or business that we're engaged in? But I also don't see them as unrewarding or not worth doing. It's just, again, that dilemma, that hurdle, that work that needs to be done that we might not have the answers to today. You heard Chief Pomprion speak about the Chiefs Association and sharing conversation, concerns, issues, new experiences. And while we have not, the sheriffs have not been communicating specifically on this topic recently, we also do the same thing. We work with the Chiefs Association, the Department of Public Safety, to talk about new things and new ideas and new ways to deal with things. And so that is always an ongoing effort which I personally appreciate that we have the opportunity to work across multiple organizations in the state. And that is actually, while not necessarily unique to Vermont, it is broadly unique in the United States. Other departments in other states look at us and say, "You do what? The chiefs and the sheriffs talk?" And it's like, we don't really talk. We work together. We have to. So I do appreciate a lot of that, but it's also the common phrase that I'm sure you've all heard. It's like making sausage, and sometimes people don't like to see how it's made, but that is what we do on the daily.
I appreciate that. Thank you. Other questions, Senator Mahowski?
I just had a quick follow-up to my earlier question. Is Essex County the only sheriff's department that's not part of your association?
The Franklin County Sheriff's Office is also not part of our organization.
Great, thank you.
Other questions? Barbara?
My question,
Rachel.
thank you, Chair Lalonde. So my question may not be for you, but it just dawned on me. So I'm wondering, as technology and information from technology has changed, how does the fair and impartial policing policy address information obtained through technology?
I have no idea.
Yeah, all right. No problem. It's I think when you were talking about you can identify things and not be yeah. So I'm not sure who I should ask that to, but I'm curious. I don't know if maybe the AG's office. No, not the AG's office. No. Okay.
The Criminal Justice Council?
So,
I'll try.
yeah, Executive Director Brickell, are you still on? And would you be able to answer Barbara's question, which she can repeat for you? I'm not sure if you're still there, though. Yep, you're still there. You want to repeat the question for?
Sure. With new technology and information coming from different technology, how does the fair and impartial policing policy address the use of information that comes from these technological things?
I'm not sure that I completely understand the question.
Okay.
How I'm taking that is maybe relative to if there was a different way we receive technology on race data collection, but that would be, it would still have to be through a technology that we can receive and make available to the public. I don't know if that really answers your question or not.
No, it's more. So I know that there are traffic cameras, drones, whatever, you can help with that. Okay, so I'm just wondering, information may come to a law enforcement organization, either from another source, somebody's doorbell, whatever. So I'm just wondering how whatever comes to a law enforcement officer's attention that gives information. Sometimes it's visual. Is there anything?
Is it how much information is collected through electronic surveillance?
No, what is done with information that might, well, I'm curious about that too, but what is done with information that comes in through technology as it changes all the time? And how does the fair and impartial policing policy stay up to date with how technology is affecting it?
I think the best answer to your question, it's not really a question of how does the fair and impartial policing policy keep up with it, because the policy is really a guideline on what law enforcement should and should not do, what they are allowed to and not allowed to do. As far as violations of that policy, those would be, they would come to the council through the Act 56 process. And we do, as do agencies, accept information from any type of source, whether that be digital, whether that be video, whether that be witness interviews, recorded interviews. I'm not sure that best answers your question, but the policy itself isn't dependent upon technology or technology changes.
And it might not be in violation if it's not addressing it. I mean, it's almost, yeah, anyway.
Okay, so we're gonna have Commissioner Morrison up in a moment and she can follow up on that question. Oh, but first, Senator Bowski.
Yeah, it is a little bit of a follow-up from Representative Rachelson's question. And it's to give an example of things that have been seen in other places where, say, automatic license readers are placed in specific neighborhoods in a way that shows bias. And so I think, you know, when I think about how would the fair and impartial policing policy respond to that, and how would a complaint even happen? Because how would a neighborhood know that that's how they had been placed? So I think this is a bigger systems issue around, to Representative Burdick's point, how we are ensuring that electronic surveillance is not biased and that information isn't being used in a biased way. And maybe that is a question for the Criminal Justice Council. Maybe it's a question for Commissioner Morrison. I don't know. But it's sort of, to me, it's sort of the interplay between data privacy, electronic surveillance, and this fair and impartial policing policy.
So before legislative council wants to weigh in, and then we'll go
Yeah, so speaking about like the ALPR system and the ATLE system, so there are laws on the books in Vermont that restrict how that information can be used, and it's quite limited. So specifically in the automated traffic law enforcement pilot program that's on the books right now, and the House Transportation Committee is actually discussing this currently. It's not up and running yet. It's a 2-year, little less program with extreme, but it's designed to not be a dragnet, for lack of a better term. It's only supposed to be used to gather license plate data, only license plate data, and the data collected for that purpose shall only be used for that purpose. So to get to the larger question is that right now the statutes that we have on the books of Vermont limit the use of that information only for the purposes of that statute. It may have some interplay with the fair and impartial policing policy, but right now, my understanding is that those technologies really aren't used in mass in Vermont currently.
Did any of the other witnesses want to weigh in on that, Executive Director Burkell, or?
No, I think that explanation was relatively straightforward. I think that, you know, we wouldn't at the council speak to what type of monitoring devices or electronic surveillance is used, and we wouldn't have any application to that. We review information that is sent to us based on complaints, and I don't believe law enforcement would be the best avenue to answer those questions for you, I believe.
As a follow-up, is there any addressing in the fair and impartial policing of things like data scraping or seeking out information, whether it be from private sources or public sources, and how that should best be done if it is being done?
There is no information in the fair and impartial policing policy reference to any of that you've just mentioned.
Thank you.
Any other questions? All right, thank you very much, Sheriff, and the other folks there, and we'll turn to Commissioner Morrison. Thank you for being here.
Good morning, Senator, Representative, and company. Happy to be here. How are you? Do you want me to start there?
Sure, yeah, why don't we start there, and then if you talk a little bit about the fair and impartial policing, and then also, you know, other cooperation that's necessary with
Sure.
Border Patrol and such.
Thank you.
Thank you.
My name is Jennifer Morrison. I'm the Commissioner of Public Safety. I began my law enforcement career in Vermont in 1990. Don't have to snicker, but that's a long time. So I spent my career policing in Chittenden County, in Burlington and in Colchester. And I was involved in the earliest iterations of the fair and impartial policing policy, which Senator Vyhovsky, I think it's important for you for context to know that that policy began as an anti-profiling. It was a bias-free policing policy is what the name of it was. It did not contemplate immigration in any way, shape, or form when it was initially developed. And it was specifically related to profiling concerns that were raised down in New York City and in other municipalities. And to tie this piece of it, one of the foundational pieces that has been in the policy since its very earliest drafts includes not allowing any personal characteristics to influence the action that the officer takes unless it is directly germane. So the fact that I'm going to use your example of technology. I'm going to say a Ring camera. The fact that the police might come into possession of some Ring camera footage, the personal characteristics of the people they see on the Ring camera could not be considered unless their clothing matched the description of the suspect, or their race, or their hairstyle, or some other identifying personal characteristic directly related to investigation and detection of a certain crime. So to answer the question about the FIP policy and technology is, in my 35 years, the way we receive information has changed dramatically. Like, we didn't have cell phones when I walked the beat and when I was answering calls for service in the city. We went on witness descriptions. We went on the other witness's description, which rarely matched. So the way we have collected information and the way technology has dropped volumes of information into the hopper has changed, but the way we use it has not since the earliest days of this policy. So personal characteristics on their own face cannot be considered in whether or not you pursue an investigation or you detain someone. It has to be because those personal characteristics directly link them to the report of a crime. So I hope that's helpful in terms of the technology. And I don't think a policy like this could be adapted to the constantly evolving ways technology works. But that's not to say there couldn't be model policies in other spaces that could be a complementary piece to this. So as I said, I have been involved in the creation of what used to be called a bias-free policing policy since around 2010, 2011. And this policy has morphed through the years, and I don't have it in front of me, but I believe the first time that it truly became more heavily concerned with immigration was in the 2017 rewrite of the policy. That was extensively scrutinized by the Vermont Criminal Justice Council, by stakeholder communities, by the general public, by legal experts. And I believe that is when the shift really happened to the FIP policy becoming very heavily engaged and contemplating these issues of how do we cooperate or not with federal partners when they want to look at matters related to immigration, whether that's civil or criminal. So all of this is to say that the policy has morphed and become responsive to contemporary needs as those needs became known. Obviously, the most recent update was more recently than 2017. And the immigration side of the policy, so to speak, became more and more the sort of prime focus. I believe that I can say pretty comfortably that issues around racial profiling that drove the policy back in 2011, 2012, 2013 have been trained out of and cultured out of police agencies, at least in Vermont. I do not wish to speak for the broader national picture, but racial profiling concerns are not as rampant as they were in that time frame, and we have made tremendous progress through training, through policy, and through accountability, holding our members accountable when they stray from those areas. So I'm going to repeat just a little bit of what I said in Senate Judiciary yesterday, because I think it's important for folks to understand that This policy has not only been revised and updated with tremendous input over more than a decade. It was developed at a time of what I'm calling blue sky days. It was developed during blue sky days with clear-headed thinking, not in the midst of a time of great fear, which I recognize and appreciate that this is a time of tremendous uncertainty and fear for some members of our communities. But this policy was designed on a blue sky day precisely for a rainy day, and it's a rainy day now. And the policy is proven. There has not been an incident or a time, to my knowledge, where something has happened and people have said that is a failure of policy. We need to revisit that. We need to crack open the policy and rewrite that section. The policy has withstood the test of time to date. And I believe that trying to contemplate revisiting it in this chaotic time is not in anyone's best interest. So I believe that the policy will see us through this very rocky time that we are in. I also want to just make a couple quick points. I made some of these. I won't go through all of them that I did in Senate Judiciary yesterday, but changing our course, becoming a sanctuary state in any way as contemplated in S-148 would immediately draw us into conflict with the federal government. That would probably create litigation that would outlive this administration. Might outlive many of us in these roles, right? So I believe it brings us into a very unwelcome place that would not get us the end goal we're seeking, which is for federal officials to not engage in behaviors that have been identified as harmful to our communities. I don't believe it would accomplish that goal because we'd be tied up in litigation for the next several years over it. I talked extensively, and I would refer you to the record from yesterday's Senate Judiciary hearing. I talked extensively about the federal funding that would be at risk, and that's just from the Department of Public Safety side. It is an absolutely staggering amount of money and programs that are dependent on federal dollars that would be at risk if we became a sanctuary state and moved forward in that way.
I'm going to just ask you a question about that.
Yes, sir.
For clarification. So the fair and impartial policing process policy itself, that doesn't make Vermont a sanctuary state?
Correct.
Then how do you define sanctuary state? Just so I understand that a little bit.
Well, I don't think anyone cares how Jen Morrison defines it, but so the policy is compliant with federal law. So it says right in it that nothing in this policy should be construed to be adverse to 1373. And I can't remember the number of the other statute. I could look, but I didn't bring my glasses. So 1644. Essentially, there's a savings clause in there that allows that we are not in violation of federal law. And that is, in fact, how things operate in the field, is we don't violate federal law. So the issues, the fair and impartial policing policy in our current status quo does not put us in violation of federal law. And it allows us to sign attestations saying that we comply with all state and federal laws. So that's sort of the line in the sand that we should not cross. Or we risk tremendous financial hardship, and not just in the criminal justice space and the Department of Public Safety space, which includes funds for our forensic laboratory, our Division of Fire Safety, our urban and search and rescue teams, et cetera. This is way more than things that support the Vermont State Police. Federal funding would be at risk across the entire Department of Public Safety portfolio. So aside from the financial impacts and risks, I think it's important, and I know Captain Skip Barnes is going to speak about the cooperation between the Vermont State Police and our federal partners. So I'm going to keep my remarks pretty high level and harken back to my municipal policing days to say that I've been in this game for 35 years, and I've never once been asked by our federal partners to assist them in enforcing civil immigration orders, or even to assist them in the removal of somebody who's in criminal violation of immigration laws. I've never been a police officer. I've never been a first line supervisor. I've never been a lieutenant. I've never been a chief. I've been in the position to say yes or no to that question. I have been in the position many, many times of relying on Customs and Border Patrol and other federal partners, including ICE, to help us protect victims of human trafficking, to help us investigate sex crimes against children, particularly online crimes against children, and the dissemination of that material. I have been in many situations where I've either been the investigator or been the supervisor of the investigation, where using those federal partnerships was essential to identifying perpetrators, holding them accountable, and protecting Vermonters. So the notion that we would, go ahead, sir.
Can we still work with the federal government on those issues?
Yes, we can. Right now, the fair and impartial policing policy does not prevent that. Taking things to a new level could make it extremely difficult because it's very hard to unbundle when you're investigating a crime that involves people in other countries, shall we say, or from other countries, or actors in the United States who, in the course of investigation, it may become known that they are here without lawful presence. It makes it very hard to untangle those issues. So a blanket prohibition on not working with our federal partners on any issues related to immigration would be an impediment to protecting Vermonters. But the fair and impartial policing policy does not prevent that. And that's why I will say again that we have found the right balance after more than a decade of this work. Sitting in the Migrant Justice Office, I sat with Will Lambeck from Migrant Justice in their office 10 years ago or more, when we were initially trying to hammer out these issues. And we have continued to come to the table with an ever-expanding group of stakeholders to make sure all the voices are heard and represented. And this policy represents that balance. Taking it any further would be harmful to Vermonters, is the point I'm trying to make. So the other aspect that I just want to weigh in about the cooperation with our federal partners is that Customs and Border Patrol, by nature of geography, is frequently the first responder to crimes that happen in the state of Vermont, crimes or emergencies. Perhaps not a crime, but say there's a bomb threat at a school up in the border area. Customs and Border Patrol is very commonly the first one on scene. I can think back, as I mentioned in Senate Judiciary yesterday, to an incident in North Hero, on the northern end of North Hero, just before Alberg, where 3 armed men got in a gunfight over rights to a piece of a hunting parcel in the driveway of a home in North Hero. And the first people on scene rendering medical help and buckling up the third guy who wasn't mortally wounded until cops could get there and sort it out were 2 Border Patrol agents, before the sheriffs and before the state police could get there. They respond when they know there's a domestic violence call, an assault in progress, because they're closer. And losing that level of cooperation on day-to-day emergencies that impact Vermonters would be a detriment. So the FIP policy allows for that, and that has worked very, very well in the interests of Vermonters and has not put any Vermonters at risk of immigration action or negative impact. So again, I throw out that the FIP policy works, and that is as far as we should take things. I'm happy to answer questions, or I can turn it over to Captain Barnes.
Questions? I'm sorry, Senator Mahowski first.
I have a couple questions. I'm wondering if you can point me to the data that shows a reduction in bias in policing and the racial overrepresentation in traffic stops and our corrections facilities.
What?
So you had said early on that we have seen a reduction in racial profiling and the impacts of racial profiling. I'm wondering if you can point me to the data that shows a reduction in the bias that we have seen in traffic stops in Vermont and the overrepresentation in our corrections.
Well, if you want to adjudicate race traffic data here in this committee, it's going to be a long, long morning. But I can point you to data that would indicate that the disparities in traffic stops has improved, has gone way down.
I just haven't seen it.
Corrections, I can't speak to that.
I haven't seen it, so that's.
Okay, absolutely happy to follow up with you on that.
Thank you. And then I also recognize that in your time, 35 years in policing, there's been very little instances of being asked to engage with immigration. I'm wondering if in that 35 years, you've seen what we're seeing right now, which is masked hooded federal agents abducting people without due process into unmarked cars. Like, I think things have changed pretty significantly, pretty quickly. And so I'm just wondering if in that 35 years, you've seen similar actions from the federal government.
So I want to be clear that I don't subscribe to your description of what happened. I believe you're talking about the Colchester incident, but I'm just making that assumption. It's neither an abduction, it's a call-in. It's a very common tactic when law enforcement is planning to arrest someone or take them into custody, to bring them to a safe space so that they don't have to enter a home where things sometimes get very dangerous for both law enforcement and the person. So when a law enforcement officer, whether they're federal or state or local, has the authority to take someone into custody and they do so in a safe manner, I call that a win. I don't believe they were masked, but if I'm wrong, I'm wrong. And would my squad, if I was a supervisor of a local squad affecting that arrest, would we have had our name tags on and our paraphernalia identifying us? Yes, we would have. But that's the way we roll in Vermont, and I can't control how our federal partners affect arrests. So I take issue with your description of the event, but I concur that we've not seen high-profile incidents like this in the volume that we've seen since the Trump administration took office. So I concur with you.
I appreciate that. And yeah, I'll just leave it at that.
Other questions? Representative Harvey.
Thank you, Chair. Commissioner, thanks for being here this morning.
Thank you.
The original FIP policy, was that in response to stop and frisk in New York?
Yes.
Okay. In terms of the federal dollar amount that you think could be at risk if some of the legislation is passed by either the Senate or the House, do you have a figure of impact?
I would have to do some math.
That's okay, you have to get back to us.
We can, and we've actually, that document has already been shared.
Okay.
There is a combined document across all departments and agencies that the Agency of Administration provided because they gathered it all into one central place. So I'm confident that you could get it or I can have it sent to you.
I can find it. And my last question
Okay.
is, what I'm hearing in your testimony is that your federal counterparts have been great partners to you throughout your career in law enforcement. And if some of the legislation is passed that's being considered by either the Senate or the House, do you think we run the risk of them not taking our call?
Absolutely.
Yeah.
100%. Yes, my relationships with all federal agencies, but for the purpose of this committee, for this hearing, specifically to those on the northern border, has been outstanding. Even as an interior community in Colchester and Burlington, we partnered with them on mostly technological investigations, but also when there were concerns around human trafficking, drug smuggling, guns, which is increasingly become the thing for guns to move north because they're so hard to get in Canada. They're worth a lot of money up there. So they have been great partners, and I don't have a crystal ball. I don't know that they would shut off their cooperation, but we would be less safe as a state if they shut off the reciprocity that they have shown.
Thank you.
You're welcome.
Not seeing other questions, if we could have the captain join us then.
Thanks, sir.
Very much, Commissioner.
Good morning.
If you identify yourself for the record, proceed. Thanks.
Yeah, I'm Ashley Barnes. I'm the Special Investigations Captain of the Vermont State Police, which means I oversee the Governor's Executive Protection Unit, the Narcotics Investigation Units, the Vermont Drug Task Force, as well as the Vermont Information Center. And this month I'll hit my 20th year in the retirement system.
Congratulations.
So yeah, I'm here to speak specifically about the working relationship between the Vermont State Police and Border Patrol. So I'll give you some examples that I hope will paint a good picture of how this works. So on a very routine basis, things as small as intoxicated operators will be reported by Border Patrol to Vermont State Police as they try to enter Canada. So, they'll be driving on Vermont roads intoxicated. They present at the border, and then they are screened for DUI. Some of the bigger cases, I'll give you some examples. In this one, if people have questions after, we can discuss. Some of these are ongoing investigations, so I'm not going to get into too much detail. But in this particular instance, an out of country crime group is moving their narcotics through Canada because it's easier to move for them through Canada than it is for the US. And some of that is making its way from Canada, specifically through the Vermont border. Some of it gets distributed here in Vermont. The rest of it makes its way down the eastern seaboard. Without the Border Patrol's cooperation, that would be not only incredibly difficult to detect, but it would be very difficult for us to investigate that as a state police agency solely. Weapons is a very similar case. I personally have investigated illegal weapons, specifically silencers that were being moved out of China through Customs and Border Patrol, and it was their intel that was provided to me, to the Vermont State Police, that allowed us to even know that was happening. That expanded into a much larger case that was tied to a white hate group out of Virginia. As far as human trafficking, kidnapping alike, the Vermont State Police investigated a kidnapping of a female juvenile out of Connecticut. She was abducted at knife point. She was put into a trunk and bound. She was brought to Vermont where she was sexually abused for several days. State police detectives were following up on that. We're kind of one step behind the perpetrator, finding them on video at, say, like a Cumberland Farms or a store, always one step behind. They reached out to Border Patrol in case they were trying to make their way north. And it was, in fact, Border Patrol that made the stop, that located the vehicle and found the female. And of course, that person was charged in multiple states on several crimes. So as the commissioner mentioned earlier, the northern border, as you all know, is very rural. It's a large area, not a lot of law enforcement. It takes time for VSP to respond to crimes, and not just crimes, but emergencies. School swatting threats have been one example where Border Patrol was there first to help get children out of a school. They're often the backup for the state police trooper who gets there alone at domestic assaults, at car crashes. There's been times that they have rendered CPR and other life-saving measures, either before troopers get there or assisting VSP in a backup capacity. As many of you, I think, would know, but if you don't, the state police go off duty at 2 a.m. We come back on at 8 a.m. During that time, when there's a call out, the trooper responds to a domestic assault, something of emergency, could be a crash from their house, and that takes time because they could live an hour away. It is a regular occurrence in northern Vermont for Border Patrol to get there first, and often they're there before EMS, they're there before fire, and they are rendering life-saving aid, or they're holding a perimeter, keeping people safe, getting them out while the investigators from the state police get there. The state police often utilizes the K-9 program for the Border Patrol. They do that to find lost hikers, injured hunters. We utilize their resources for ATVs, UTVs, snowmobiles for the same reasons. They have a lot of resources that they can get there much more quickly, and they have the additional manpower to help with these instances. So, I mean, I can keep giving you more examples, I think, but I think I've made the point. It would be very difficult for the state police by themselves to investigate criminal activity crossing the border, which is a very real thing here in Vermont, and and I don't have the data on hand, but from anecdotally, or it feels as that has increased, as we all know, gun violence and major crime in Vermont seems to, 20 years ago, as a young police officer, it certainly feels much more prevalent. Without their resources, without their cooperation, it would be very, very difficult for the state police to handle calls for service in the northern area, which ultimately makes it less safe for the citizens of Vermont.
Questions for Ken? Don't see any questions, so it's very helpful to get the details of some of the cooperation that's happening.
Sure.
Appreciate your testimony.
All right. Thank you.
Thank you. All right, so we're gonna take a 10-minute break before we get to the rest of the.